My talk today will be based on, or is part of a European project. It's part of the 7 Framework program, which is called Practice. As you can see, it is somewhat with a little bit of imagination, the acronym of privacy appraising challenges to technologies and ethics. No, we know that we did not solve all the current issues, but this project looks into future technologies. Future technologies, we are looking into technologies that are likely to be in broad distribution within the next 20 years. So our consortium is composed of quite a few teams across Europe and Israel. And one of the teams is busy doing, or was doing, technology forecasts. And apparently there are methodologies for doing that. And their report, as well as other of the team's report, are available on the Practice website, with the caveat that we have been hacked recently, and I believe by a Yemenite group of some sort, but I believe that it has been restored. So one basis of the project is the technological forecast of the next 20 years. Another element was a 6-nation high school survey about high school students' perceptions about privacy, what is important to them, etc. Quite a wide sample of students, and then some ethical and legal discussions. In this element of the project, we try to assess the legal implications of these future technologies. So we are way into the future, 10, 15, 20 years, maybe even beyond that. I'm on the legal side, not the technological side, so I will not be able, I'm afraid, to tell too many kind of high-tech science fiction-like stories, but some of them might come up in the process of the discussion. Very few quick assumptions of the project. First, as David has mentioned, privacy is important. Privacy is a basic fundamental human right, Otherwise, the entire project will be quite a waste of time. Another basic underlying assumption of the project is the relationship between law and technology. Unlike the popular saying that the law lags behind technology and technology develops in its own world according to its own rules, which is quite a popular view, we believe that the law and technology do have a complex dialectical relationship. Each of these social elements influences each other. Hence, technology can be regulated as a matter of fact. Whether it is wise to regulate technology or not is a different question. On occasion, it might be quite difficult, expensive, etc., or not always, just simply not always the wise thing, but technology can be regulated. Another baseline assumption is that it is quite unlikely that we will come up with a single magical solution that will solve all privacy or data protection issues. Hence, we opt from the very start for a basket of solutions that we are busy working on and will recommend, which include legal measures, but also technological, social, organizational, as we've heard, ethical, etc. So the regulation of technology need not necessarily be by regulation, by legal regulation. It can also be in other ways.